What's going on, everybody? Welcome to another episode of the Justice Revolution. I'm your host, James the Patriot. We've got my partner in crime, no pun intended, Erica.
Hey, James.
How goes it? I just love that background every single time you jump on. I love that background.
Yeah, I hated that wall, remember? And I just decided to paint it one day.
That's right. That is right. I do remember that. So
yeah.
We are thrilled to have with us a very special guest. Most of you know him on Telegram as Be Free, I believe is his Telegram handle. He's also a co-host with the one and the only Randy Kelton on the Rule of Law Radio. So we're really thrilled to have the Mr. Brett Fountain with us today. Brett, say hello.
Hey there.
Thanks so much for joining. I really appreciate it.
My pleasure.
So I reached out to Brett. I thought it would be a good idea. Really just to kind of talk a little bit more about, what to expect when we're bringing these cases through the federal courts. Brett had posted a motion in, what group was that in? Was that in Randy's group or I don't remember. It was in one of the Telegram groups that you had.
I think I posted it in just a channel that I started for the speeding ticket.
That's right. Yeah. It was a speeding ticket channel.
Yeah.
Yeah.
So that people could follow along real time with here's what's happening with the speeding ticket. Perfect. You never know if it's going to be sometimes be a quick thing that's over or if it's going to go into this long drawn out battle, which this one is.
Yeah. Well, so why don't you bring us up to speed with what happened? We were talking a little bit before we went live about this, but if you wouldn't mind just giving everybody a background on what's the situation with this case. You're in federal district court. We just give us a brief update.
Yeah. So in the federal court, we don't have any of the speeding issues before the federal court. That wouldn't be appropriate, right?
Yeah.
That would be out of scope for them. So what they are dealing with, what I have brought to the federal court is a violation of my due process rights. The federal Constitution says I have a right to due process.
Mm-hmm.
And here in the inferior state court, in the JP court, we have a prosecutor who is persistently pushing his own agenda, just completely lying about everything and bamboozling the judge who, she's not an attorney. She just looks to him because, wow, he's got a bar card. He knows his stuff. He's a professional. Look at his $1,000 tie. I mean, she's impressed. So whatever comes out of his mouth, she buys it. But he's lying. And so I've got right now, before the federal court, I've got him for 15 counts of aggravated perjury.
Love it.
And thereby depriving me of my right to due process. It's nothing about speeding, nothing about the merits of anything, whether or not I have a right to travel, none of that. It's only about this dude's over here committing aggravated perjury. That's a crime. It's objectively unreasonable.
Mm-hmm.
You can't say he's, acting in scope. One of the lies that he told is that he's authorized to be the prosecutor, and actually he's not. So that, he does some contracting work for him sometimes.
So did he, I guess, and maybe we need to back this up a little bit, because I'm not entirely certain that people often understand what constitutes perjury before the court. Because oftentimes, for those of us, those little, as Alphonse says, those of us little monkeys that are moving our own cases through the courts, we will back everything up that we do with a verified affidavit or a verified complaint, right? So we're putting our neck on the line. But
Sure.
then we get these run-of-the-mill liars, as we like to call them, that they just file whatever they want and they just seem to get away with it. So what exactly did he do, or what would constitute perjury before the court?
Well, this is a 1983 suit, so Title 42, U.S. Code 1983.
Mm-hmm.
And that means that it is a state actor who is acting under color of law, and he's violating state law in order to deprive me of my federally protected rights. So to talk about what is aggravated perjury, we go look at the state, Texas, this is in Texas, and we go look at what does Texas say is aggravated perjury. Well, if he makes a false statement that is in connection with an official proceeding and it's material. So he knew this was false when he said things like, "Oh, I'm a prosecutor. I'm authorized to prosecute this case." There was no case. He never even started a case. Nobody started a case. There's not even one shred of paper in there. So that's a lie. He knows it. And he made this false statement under oath, and the statement is required or authorized by law to be made under oath. So, he's over here pretending like something's true when it's not. So he meets all of the elements: intent to deceive, knowledge of the statement's meaning. It was made in connection with official proceeding, and it's material. So perjury is different from aggravated perjury only in materiality. So if I lied and I said, that wall behind Miss Erica here is not colorful at all. Well, that's a lie, but it's not material.
Yeah, it doesn't. Yeah, because it doesn't have any bearing on the case at hand. Correct.
Right, but the things he was lying about are material.
Yes.
For instance, he told the judge, this justice of the peace, he told her, "Oh, jurisdiction, that's not important, Your Honor. The only thing that comes up in civil matters. This is a criminal matter."
Well, wait a minute. I'm confused here. Now, hold on. Back the freight train up here, Mr. Brett. I thought you said that this was a speeding ticket situation. That's a crime. I get all sorts, because I don't know what it's like in Texas. Here in Utah, where I'm in, if we get a speeding ticket, that's not a crime. That's an infraction.
Yes. By state, they've defined it two different ways. It's either civil infraction or criminal. It depends on the state. Some states, they categorize it as a crime. Texas does.
Okay.
So what they will do in states like yours is they will say you failed to appear, and then they convert it into a crime, because failure to appear is a crime. If you didn't, handle it the way they wanted you to, then they check a box and they call that a crime. But the traffic itself, that'll be a civil violation, like you said, or infraction. Yeah, but in this case, in this imaginary case, I should say, that's in his mind, it doesn't exist anywhere else. He's telling the judge that it's criminal. Oh, and jurisdiction. Yeah, that's only for civil matters. I have a list, Your Honor, he says. I have a list for where jurisdiction would apply, and this is not one of them.
Has he ever? I'm just curious. Has he ever litigated a case before? Ever? Like,
I was wondering if it was his first time, but now he has said, and we've even had the judge testifying on his behalf, that he has been in here before and done this before. And he said at one point that he's doing these traffic cases, all of the traffic cases in all of the JP courts.
Okay.
So, yeah, I have reason to believe that discovery is going to turn into a nightmare for him.
Oh boy. Yeah, it is. And real quick too, for those of you who are not in the great state of Texas, JP is Justice of the Peace, by the way. So
Yes, thank you.
yes, no problem. Because I know here in Utah, we don't have justices of the peace, but we do have justice courts. I call them injustice courts because there's no justice being done there. It's just a glorified extortion scheme, as far as I can tell.
Yeah.
Your rights be damned, and don't bring that constitutional stuff in here. We have no place for that in this court. I mean, it makes you boggle your mind. So, yeah, this is a great question from Paul Revere. When do you think RICO would make sense?
RICO, racketeering.
Mm-hmm.
So yes, I did put a lot of that language into my suit, in my federal suit, and I did cite the section for RICO as well. I'm not harping on that, but
Okay.
I want them to feel the earthquake of it.
Yeah.
You know,
What I love about the RICO statute, for those of you who are watching this, I mean, RICO is both a civil cause of action and also a criminal cause of action. And under the federal laws, it gives us, regular Joe Blows, the right to become a private attorney general. So I love that. And, and if you can meet all the elements of a civil RICO case, you've got a pretty in-depth option there. But it does take a lot of work and knowledge to research those laws. So you filed suit in the Eastern District of Texas,
yes,
and then like these guys always do, they filed a 12B6 motion to dismiss. Correct?
yes, but guess when they filed it?
When?
After their deadline.
No, even better.
Everybody gets 21 days to answer a suit,
Yes, they
and
do.
what these guys did is, on the 21st day in the afternoon, we got a notification on the docket in their electronic filing system
Mm-hmm.
that said that there was an unopposed application for extension of time.
Wait a minute. What?
Yeah. An application that had never been seen and apparently still doesn't exist was brought to the attention of the court as being unopposed.
By whom? Unopposed by whom?
Some non-party filer, which was a law firm that immediately earned a bar grievance from me. And this law firm put something in there. They didn't even have a notice of appearance of counsel. So who is this that's stepping up and saying that there's an unopposed application for extension of time, which is a lie?
I'm very confused now.
Yeah,
so you're telling
they
me
are too.
You filed suit, you properly served the other party.
Yes.
Now they have 21 days to answer, which is the case in all federal courts.
Right.
And instead of doing anything on the 21st day, you get an unopposed motion for an extension of time by not the party you served, by some random law firm?
Exactly.
Now, are they representing this joker?
A few days later, they did, yes. It was 5 days after their deadline that I got something in the mail that said notice of appearance of counsel, and it was filed with the court 3 days after their deadline.
Oh, gosh.
So, yeah.
So now you've got these, and this is something very similar has happened to me too, and this is what really, you want to talk about procedural and substantive due process rights. By the way, we need to clarify that, so don't let me forget that, Brett, the difference between those two.
Okay. And RICO, we'll go back and explain.
Yeah, and RICO. I do want to get back to that. Thanks. By the way, that's my producer, Justice. She's actually feeling under the weather, but she's in the background throwing up those questions on there for us. So, yeah, I'm still trying to. I mean, this. I don't know if maybe COVID has made people's heads go bonkers when it comes to the courts and the processes that have been well established for over 100+ years. I don't understand it. I mean, it's cut and dry. You have 21 days to respond. I don't know what it's like in your local court rules there in the Eastern District of Texas, but here in Utah, they can get one they can file one motion for extension, and the court clerk can grant that. They can get an extra 14 days. I mean, that's not hard to do.
They can do that here too if it's unopposed.
Exactly. Yeah.
Which this one wasn't.
But that's my point. I don't. Oh, okay, so let's hold on to that thought for a second. Let's talk about RICO. So RICO is an acronym. It stands for Racketeer, Influence, Corrupt Organizations.
Yep.
Essentially, what it is if you have corporations or people pretending to be a corporation, i.e., like what we're talking about here, that are just sending out statements for money, and they're just trying to extort money from people. Congress back in the day, I don't know when was this passed, in the 70s, I think 70s or 80s.
Yeah, I think
they said they said this is a big problem and we need to curb this. And so we're going to be able to allow, they codified into the criminal procedure in Title 18, which is the United States codes or criminal codes.
Mm-hmm.
And then they also codified it as a cause of action for individuals on the civil side. So I don't have a lot of time, and I don't want to get off too far into the weeds to discuss exactly what RICO is, but that's it in a nutshell, unless I missed anything, Brett, that you want to add to that.
Yeah, just organized crime. When there's a pattern and a practice, their whole plan is to keep doing these crimes so that they can keep raking in the money.
Yep.
That's what I filed. That's what I filed as a complaint, criminal complaint with the state about the hospital.
There you go.
With the government. Two criminal organizations trying to profit off of like what they were trying to do.
Yeah.
And Brett, by way of introduction, by the way, Erica is actually a former critical care nurse, and she was in the right in the heat of all of this madness, and she was like, guys, I'm not doing this stuff. This doesn't make sense. And
wow.
And they ultimately fired her for not wearing the face diaper.
Nice.
And so now she's
my body needs oxygen. I don't know about anybody else's, but
yeah, whatever. No, that's all relative. We've already had this discussion, Erica.
I know. It's like being a dead horse.
Exactly. So that's her background, and that's where she comes from, which is why I invited her on to be as my co-host. So all right, now let's go before we move a little further forward with where this madness is in your case, Brett. Let's talk about substantive and procedural due process rights. Can you give the dumbed down explanation of what those two words are and what they mean?
No, not really.
I know it is difficult to really understand. So let me give you my layman's terms. This is where we really need Randy, right? So my dumbed down version is this: is your substantive due process rights are those that are written down that you can see. So from my understanding, the rules of procedure, either the civil rules of procedure or the criminal rules of procedure, whichever state you're in, or even if you're in the federal court, those rules constitute your substantive due process rights, because if this doesn't happen, then here is the consequence, right? So
yes.
in Brett's case here, he filed a lawsuit. He served the other the party properly. An affidavit was returned saying that they were served. That goes into the record. They have 21 days to respond. 21 days comes. They don't file a response. They don't even do anything they're supposed to do procedurally. And 3 or 4 days after that date, that's when they decide to get on there. So by the court, either if the court grants this extension or if they deny Brett his right to default judgment, they just denied him his substantive due process rights.
Yes,
So
and they've actually done both of those.
Yeah.
We had a magistrate judge. You know, in the federal court, you have these almost judges. They're not Article 3 judges. They're not judges who are responsive to the electorate, but they're helpers, associates, kind of. They're going to be a judge one day.
They want to be a judge one day. Let's back up a little bit. They want to be a judge one day.
Are you saying we might want to have something to say about that? Well,
we may have, and I've got something on this one too. But yes, please do. Please keep going.
So the magistrate judge ruled after looking at the notice of an unopposed application and looking at the fact that there was no application and looking at my same day opposition to any concept of there being an extension of time, particularly without them following the rules, which say there has to be an unopposed one before you can even file it. So, and then they granted the extension of time, gave them 30 days. Also,
30 days?
Yeah.
What?
Yeah, exactly. So 21 is not good. You can sit on your butt for 21 days, do nothing, and then get another 30 days for nothing, even though the person who lied and said that there's an unopposed application isn't even a party to the case.
They must play golf together or something.
They must. They must.
So then they also denied my motion for default judgment, which went in immediately after the 28 days was up.
After the 21 days, right?
Yeah. They missed their 21-day mark. I put in a motion for default judgment, and it got denied as moot because they're getting an extra 30 days, of course.
Yeah, that's wrong. That's just wrong. But anyway, keep going.
I agree. So I noticed that in the federal rules of civil procedure, there's a Rule 72 that says that you can challenge what a magistrate judge comes up with, and you can say, look, something's wrong with this ruling. Put it before a real judge.
Yep.
So that's what I did.
It's Rule 72 for those of you listening. I know that rule very well because I too have had to deal with magistrate judges, and they are a royal pain in my side.
Wow. Well, sorry to hear that, James, but the fellowship of suffering. How about that?
Amen. Amen. So let's just go ahead so everybody has here. Let me pull. I'm just trying to pull up my Cornell Law page, and I just want to show everybody what you're talking about, because sometimes these just being able to see things is what you'll be able to put it in context is what is helpful.
Yeah.
So let me go back and I'll share my screen, and then we will show you what we're talking about here. So let's go to this one here. Okay. So for those of you who are watching, the United States Magistrate Judge is actually codified in U.S. law. It's 28 U.S.C. 636. This is a lot of words here. I'm not going to bore you all with that. But this is basically what gives the magistrate judge its powers. Anytime you file a case in federal court, the very first thing you're going to get from the court is going to be a packet that says, we want you to consent to a magistrate judge hearing this case. I'm assuming you got that packet, Brett?
Yeah, they sent me that. I did not consent to it.
You do not want to consent. You do not want to consent.
All right.
So let me go here to the Federal Rules of Civil Procedure. Let's talk about that. Magistrate Judge's Pretrial Order, Rule 72. So this is what Brett was talking about. So the situation before the court, the order is on the extension of time is a non-dispositive matter, meaning it's not going to dispose of the case one way or another. So when that happens, and in Brett's case, when that happens, Brett has 14 days to file an objection. This is what irritates the living daylights out of me about this magistrate judges. More paperwork for us to do.
Mm-hmm.
It's another motion or an objection that we have to file and we have to put in before the court. It takes up more time away from us being able to litigate the case that we want to before the court. So now this is what Brett has to do. He now has to file an objection before the court, and that objection actually goes to the district judge, and the district judge is required to review it. So
I mean, ignore it in the order in which it was received?
Essentially, yeah. So when you look at the rule, it says here, a party may serve and file objections to the order within 14 days after being served with a copy. A party may not assign as an error a defect in the order not timely objected to. The district judge in the case must consider timely objections and modify or set aside any part of the order that is clearly erroneous or is contrary to law.
Right.
Now,
so I highlighted what was clearly erroneous, what is contrary to law, and I moved for their bad ruling to be set aside.
yes. Good.
And the other one I challenged was the motion to the denial of my motion for default judgment. They denied it as moot.
Yeah, and
I called that one a dispositive motion because it would have disposed of the case.
Yes. Which, by the way, too, let's go back and review that, shall we? Rule 55, default judgment. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. So
why isn't it done then? Right.
Here's where the problem is. So you've got a magistrate judge who denied the motion as moot. The rules don't specify anything that the magistrate is to get involved with the default judgment. That's up for the court clerk. Now,
that's because it's dispositive, and the magistrate judge can only get involved for something that's non-dispositive.
Well, sort of. Let's go back here real quick, because you're going to find this, Brett, and I'm warning you. Every single motion that is filed into your case is going to be referred to the magistrate judge. It's just going to be referred. What irritates me is they're either a very, and you can tell the differences. You know, most courts, I don't know about the Eastern District in Texas. Here in Utah, they have 3 magistrate judges that are vying for a spot on the court as a district judge. Most of them moonlight as the magistrate judge. They also are still active litigators or active attorneys. So they're still liars working in their law firms.
So they can be bar grieved.
They can be bar grieved, but they can also even more than that. They can also, you can file a judicial conduct complaint against them with the appellate court. That's where it gets real fun.
I understand that it's actually even more weighty in the Fed than in the state for a judicial misconduct complaint. Is that true?
It is, yeah. So and we'll get into that here in a second, because I'm going to bring you guys up to speed on one of the cases where I'm litigating, but yes, it is. I mean, it's not as simple as, just filling out a form and sending it into like your state judicial review form board or whatever they are. It actually goes to the appellate court, and the justices that sit on the appellate court review them. So, for example, where I am here in Utah, we are in the 10th Circuit Court of Appeals, which is located in Denver, Colorado. So if we file a judicial conduct complaint against a magistrate judge or a district judge here in our federal district court, it goes to them. They actually hold hearings on it. So you can guarantee that if a judicial conduct complaint is filed against a magistrate judge, their hopes of ever becoming a district judge are out the window real quick. Great. But they just sit back and think that no one's going to go to that level because it's so rare when it happens. But when it does happen, just watch out. So Go ahead, Erica.
I'm just thinking like a nurse here, okay? I'm trying to draw the parallels between this system and the healthcare system. Seems like the magistrate is like a resident or like a student nurse or somebody who doesn't really have any authority to do anything, but they're the ones who are there. Yep. And they're absorbing all the information. I've had patients die while we're waiting for residents to check with their director, their doctor, overseeing doctor, because they can't make the decisions themselves.
Yeah.
I don't know. Is that a close comparison of what's going on with these magistrates?
It's kind of in training. It's very similar. I mean, basically, think of the magistrate as a glorified paralegal. That's really all they are. These district court judges.
Fact checker?
Well, no, you can't even call them that because they get the facts wrong all the time.
Dang it.
I know. I wish.
Like,
I wish.
Secretaries, kind of.
I wish I could say.
Judge Light.
Yes.
Judge Light.
Yes. So let me give you a real quick. Let's finish up on this, and I'll go back to my next point. So there's two issues. The magistrate judges can review a non-dispositive matter, like we just talked about in Brett's case, or a dispositive motion, which is your motion to dismiss, a motion for summary judgment, a motion for judgment on the pleadings, basically any type of matter that will dispose of the case. Now, this is what gets frustrating for us, in those of us that are litigating in the federal courts and pro se litigants, is that we want that Article 3 judge watching and looking at our stuff. They oftentimes won't see it until after the magistrate judge has issued what's their report and recommendations. And that comes from this rule here, Rule 72. It's Rule 72B1. So when a magistrate judge is assigned a dispositive motion, the rule states that they must promptly conduct the required proceedings when assigned without the party's consent to hear a pretrial matter dispositive of a claim or a defense in the prisoner petition. We don't need to worry about that. It also says a record must be made of all evidentiary proceedings and may, at the magistrate judge's discretion, be made of any other proceedings. The magistrate judge must enter a recommended disposition, including, if appropriate, proposed findings of fact. And then after that, if it's something that you don't agree with, you have 14 days to object. And if you don't object within that 14 days, there is appellate case law that says you waive your right to appeal, which is garbage, but whatever. That's what they say. If you timely object within 14 days, then the district judge must determine de novo any part of the judge's disposition that has been properly objected to. So de novo, for those of you who are following along, that means they have to review it all over again, as if it never happened. So it just seems to me like we're putting the cart before the horse. I'm going to object to anything the magistrate says anyway. Why bother having them on here? It makes no sense to me whatsoever. So that's what's going to happen 9 times out of 10 when you're putting your cases. So like in my situation, we filed our complaints. We get a motion to dismiss. The motion to dismiss is referred to the magistrate judge. The magistrate judge issues a report and recommendation. Then we have to go in and file an objection to it. And then the judge has to review the record and issue a ruling accordingly. So does that make sense on that stuff?
Yes.
So that's the crappy thing. Fortunately, Brett, that your situation that you're in, the good news is that by denying your default motion as moot, whoever this judge is it a woman or a man? This judge, do you know? This magistrate judge?
The magistrate judge is a woman.
Is a woman. Yeah.
I didn't look at the judge.
Yeah. It's
I haven't done anything yet.
It's irrelevant, but it's just like what Randy says. Well, that'll do. All I need is one thing. That'll do, and that works. And if I'm in your shoes, I decided to play nice for the first, I don't know, year and a half that I was moving my case through the courts. I'm so sick and tired of waiting on these idiots. I'm done. So you don't give me the justice I'm looking for because I know I'm in the right and I do have the law and the facts on my side. But, it's like Randy says, that's irrelevant oftentimes. So what's the next best thing? Judicial conduct complaint. I'm sending this right up to the Court of Appeals. We're actually doing that right now. My good friend who was hauled out of the state capitol building for exercising his free speech rights.
Oh, boy.
By our state troopers, yes.
On January 6th?
No, this was actually earlier this year. It was in
state
May.
Troopers.
Yeah, state troopers. Yeah, under Utah law, the state troopers provide security, whatever you want to call it, at our state capitol complex. So, yep, he was hauled out of there in handcuffs. He did nothing wrong, broke no law. They tried to maliciously prosecute him. They dismissed the case and said, this is clearly a free speech issue. He did nothing wrong. So we filed suit, and they came back with a frivolous motion to dismiss. They always do. So we objected to it. And the magistrate judge that's assigned to the case has been sitting on that for now 2 months. And this isn't the first time that she has taken months to issue her report and recommendation. On another case that we're issuing, this is really going to blow your mind, Brett. We filed, I should say, an amended complaint was filed timely. We got it to the court and it sat there. The court didn't docket it, didn't do anything. It sat there for 6 months, nothing happening.
What?
6 months. And we're like, what's going on? We were emailing the court, all of this stuff. Finally, the court says, oh, well, whoops, this was timely filed. This should have been docketed. So they finally docketed it 6 months later. Well, in the meantime, this poor guy is going through the ringer in our state injustice court. And we thought we weren't going to get any remedy from the federal court to issue an injunction. So he accepted a plea in abeyance after we had already timely filed that amended complaint. Then they filed a motion to dismiss saying, well, now that the heck doctrine applies and you can't do that and this and everything else. And I was like, oh, this is a nightmare. So we're like, okay, we're done. We're filing a judicial conduct complaint against this magistrate. I want her out. If she never sees the light of day in a federal courthouse, I would be happy. I'd be thrilled. So
It just reeks of incompetence. Like,
Yeah.
it
the whole
blows your
system.
mind.
Is this the first time in history that they're expected to do their jobs? Because people like
know.
you and I are representing ourselves and not their buddies that they play golf with. I know I'm being a little cruel, but at the same time, are they not expected to step up and do their jobs the way that, and that's the beauty of knowing how it's supposed to be, is then you can
Yes.
call it out and be like,
Yes.
yeah, that's not how it's supposed to be, fellas.
Yep.
Hmm. Exactly. And like
Yep.
James said, having some other tools that are on your belt that are not within the court case, but things like being able to report judicial misconduct or being
Yeah.
able to go report crime.
Yeah.
Say you failed or performed to do your sworn duty. The law imposed a duty on you and you failed.
And you failed
Right.
to do it.
Right.
Yeah. So
Yep.
reporting crime or reporting judicial misconduct, reporting unethical behavior of lawyers, this is very important tools to have because otherwise, if you're just looking at what's going on in the case, yeah, it can look
Right.
really dismal in a hurry.
My case presented another big whopper. Like, they're trying to protect my doctors by an ex post facto law that they created to give themselves immunity.
In arrears.
Oh, that's handy.
Like, you're not allowed to do that. Like, the attorney general sent me that message and said, I'm sorry, we can't prosecute because we've already made a law that gives them immunity. Well, then I'm coming after you too because you're not allowed to do that.
Exactly.
What is going on here?
It blows
Sorry,
your
I get fired
mind,
up.
the incompetence level. But, oh, gosh. I mean, and this is what's frustrating, right? Is and I'll just, I'll paraphrase here. In one of these reports and recommendations that the magistrate judge issued in one of these cases, she talks about how she wanted to, pro se litigants are entitled to liberally construed complaints, right? The Supreme Court has talked about that. So she talks about how, well, in order to construe the complaint liberally in favor of the plaintiff, this is what I'm going to do. And then later on, she talks about how, well, the shortfalls of the pro se's complaint doesn't, and I'm not allowed to put those facts there for him. I mean, it was like, I'm reading this going, so on one hand, you're trying to help me. On the other hand, you're not. I don't understand this. What are you trying to do here? In fact, she was openly advocating for the defendants, which was really ticked me off. And sometimes you guys have to just review. This is why it's important. Like, if you're going to that level, if you're going to the federal court, get to know the judge, and I don't mean get to know them personally, but look at the rulings issued by the district court judges. They're pretty easy to find on any law library that you're subscribed to. I use Case Text and Westlaw, and I can find most of that stuff. So that's what's interesting is when you're able to review that stuff. But yeah, I mean, it's not hard to point out the fallacies of their reports. So Brett, you posted in that group. Was that your objections to her report? I can't remember exactly if that was the objections or if it was
I've
something.
posted pretty much everything I filed into the federal court. I've posted out there. The one I think you're talking about is a response to the defendant's untimely answer.
Yes. Do you have that by chance that you can share? I believe I'm not sure if I've given you the setting.
Yeah, I'd love to see what they have to say about that.
Yeah, they haven't said anything to it yet, but
we play golf together. He's my friend.
Let's see if it lets me share this in here to you.
If you need a permission, let me know too.
Say present. Says I have no slides. Let me upload from a PDF.
It's not possible that you missed a notice or something, is it? Like,
I can see what's been filed. If I go look in Pacer, I
Yeah.
can see what's been filed. So I don't know if there's any possibility of that, but I would imagine that it would show up in there. All right. Are you seeing this here?
Yep, it's up on the screen. Yeah.
Okay, so they tried to do this Heck v. Humphrey thing where, like you just talked about, where they said, well, oh, he's just challenging a conviction in a justice court, and he had a traffic issue in a justice court. Like I said, I didn't bring any of those issues before the federal court. This is not about a conviction. This is about a lying prosecutor who actually isn't a prosecutor. That was another of his lies. He's perjuring himself and denying me due process rights by his perjury. So I'm saying here, defendant's counsel has grossly misconstrued this action as if plaintiff has sued, and these are the names of the people there, for prosecuting a traffic charge. When in fact, it's actually against Thomas, is the guy who did all the lying. He pretended to be a district attorney, and he violated my rights. So we have this here, and then like I said, here's see I'm touching on ongoing criminal enterprise, and to deprive via pattern of racketeering activity. So that's just kind of throwing some of that language in there to make them feel the thunder.
Right.
But I'm not really going after RICO here exactly, not yet. This is going to become one of the there's a PORA is another acronym they use, pattern of racketeering activity. And you show that within X number of years, there have been X number of events that are racketeering in nature. And that's what I'm going for here. This is one more of those. I've got a monster suit against Wood County, and they're going to feel a lot more than thunder.
That's going to be fun.
But here we have, so defendant Thomas, we're saying here, I don't know if you see my cursor or not, but defendant Thomas is impersonating the district attorney. This is specifically about how this is not about a traffic conviction here. There's no conviction. This is a bunch of steamrolling bogus nonsense. They're blowing smoke, but this is him. And then here's aggravated perjury. And then this other defendant here is the office of the DA. Now, this was challenged by the motion to dismiss. They said, oh, well, they don't have their own jural entity. They can't be sued, and they can't sue and be sued. I'm like, okay, that's fine. I'll substitute a different entity name here. We'll put Wood County in there instead. And I'm just throwing this out there. They'll probably challenge this too, but I'm throwing this out there. I don't think anybody needs any additional notice because it's the same exact physical person who set these policies and who already has actual notice ever since the 7th of November. So I think we could just swap out the name there of the fictional entity and just keep on going.
Yeah.
Especially since they already defaulted.
I know that's what really boggles your mind. But anyway.
So then we have defendant Albers. She really is the district attorney, but I'm not going after her in a prosecutorial capacity. She didn't do things that were advocative in nature. That's how you decide whether or not somebody has absolute immunity. If they were doing prosecutorial actions and they are the prosecutor, well, then they're absolutely immune. Doesn't matter what they did wrong. So here they're trying to invoke this absolute immunity because, well, she's a prosecutor. I don't care if she's the prosecutor. She wasn't doing prosecutorial things that I'm complaining about. I'm complaining about the fact that she's the one that made these bad policies. She's the moving force behind that whole fictional entity pushing these bad policies. So we've got Monell. The Monell doctrine is what is pulling these guys in to say that the entity is responsible for this guy Thomas. He's, over here throwing perjury around and depriving everybody's rights, but he's doing it just like he always does, and just like everybody that works there always does. Technically he's this part-time subcontractor dude, but the policies that he's following are policies to deprive rights.
Mm-hmm.
He's not just some random, or as they called, mere tortfeasor. He's not just one lone ranger out here feeling his oats and going against policy. He's following policy. That's the problem.
Yeah.
So I'm saying that under the Monell Doctrine, this fictional entity, the office, is responsible. And then we have Albers here, who is the DA. She's doing this. They call it failure to train and failure to supervise.
Yep.
That's what she's doing. And so that's in my main complaint. I'm just highlighting it again here to say that that's what this is about. This is not about a traffic ticket. I'm not trying to get a reversal of a traffic ticket conviction. That's speeding.
It sure seems like, well, I mean, and for those of you who've watched any of my broadcasts, that, if you're going to bring suit in federal court, it's about $400 just to file the suit. So I seriously doubt your traffic ticket was more than $400. And I'm not going to ask you to tell us that, but I mean, where's the logic in that? If that makes sense, why in the world would I sue someone in federal court, spend $400 to try and vacate, say, a $120 speeding ticket? I mean, that's ridiculous. But if they're violating your rights, that's a different story.
Exactly. And I told the JP, the Justice of the Peace, I told her, and it was $230 they wanted. I told her, oh, look, these guys, by all of these lies, they're ruining Texas. I don't want to see them ruin Texas.
Mm-hmm.
You're letting him ruin Texas. Don't do this.
You're allowing it. Exactly.
Right. Texas has a pretty good name. You know what I mean? Like, you guys are supposed to be more fair down there. And like,
so yeah, this was clearly not about speeding, and it wasn't about the money. I mean, yeah, I went in and form a pauperous, but they don't care about that. And they still wanted my $230. And so here I am in the federal court, and I went ahead and paid the $402 because I didn't want, there's a waiver of, you're waiving, how does it put it? It can be dismissed out of hand without ever being heard if you went in form of pauperous.
Yeah.
You seen that?
I have.
So I want them to be forced to look at this.
Yeah.
right.
So I scraped together the money, and we put $402 filing fee in their hand.
Yep. See, that's the thing too, is when you bring a case to federal court, if you don't have $400, you can apply for a fee waiver. What's irritating, though, if that's the route you go, a magistrate judge reviews your case first to determine if it has any merit, and they'll issue a report and recommendation on whether or not that the court should docket the case. It's a very frustrating way to commence a case. So I just say, hey, if you've got the $400, just file the $400, and they're forced to look at it.
Mm-hmm.
Don't. You need to get justice. You can still get justice in the federal court at no cost. However, it's just a much higher hurdle to get over.
Right. Because you're facing that same magistrate judge that apparently can't read or doesn't care.
Yep. And I love there on number 16, where you're talking about the Heck v. Humphrey, how their misapplication of that quote unquote doctrine is not on point.
Yeah.
Just so everyone's aware, the Heck doctrine set forth. So this was a guy who was convicted, and he filed. He was convicted in state court of something. I don't remember what it was. He filed a federal complaint alleging that conviction violated his constitutional rights. And the court said, no, that's not how it works. You're going to see that a lot. For those of you who properly object to the court's jurisdiction, especially in these injustice courts where they never prove up jurisdiction, it's never done properly. They can't, right? Because in order to do that, they have to prove that every element of the statute is met. including
Yeah,
a
and that the paperwork was filed properly, and that it was
exactly,
signed and sworn, and it was before an authorized individual and
exactly,
timely, and all of these things. They don't
exactly.
do any of that.
They don't. They don't. So, so you're not challenging the conviction violated your rights. You're challenging that the process that they used to get the quote unquote conviction violated your rights. And by the way, any court that is deprived of jurisdiction can be collaterally attacked in any other court. Just so you guys are aware. So, Chris brings up, and I want to get back to another question earlier, but Chris says, why would you not consent to a magistrate? Chris, again, we were talking about this earlier. Magistrate judges are really there to help push things along. They are not an Article 3 justice. They are not an Article 3 judge that is authorized under the Constitution to adjudicate matters of we the people. Hence my we the people shirt. So you don't want that, because now, again, this is what people don't understand is when you bring a case to the federal level, you're trying to invoke an Article 3 court, which moves according to the rules of procedure, which guarantees everyone's rights on both sides. Everyone is given the opportunity to be heard. So, oh, by the way, I apologize, Brett? Were you done showing your document there?
Yeah, if you want to, I mean, we can go through some more, or not.
Okay, I just want to make sure, because so I didn't want to hit the wrong button there. So, but if you consent to a magistrate judge, they want to take you out of the burdensome and the time-consuming process of the Article 3 court and put you over into the Article 1 court, the administrative court, which is what all of these JP courts, these justice courts, or these injustice courts, that's how they operate. They're moving according to the administrative procedures. And you are guaranteed no constitutional rights in any of those proceedings. And just you want to stay away from them.
It's just like when I worked in labor and delivery. Like they would ask all the patients, do you want to let a student nurse come in and check you to see if you're ready? Like,
yeah, who's okay with that?
Because there's so many more of the student nurses and the resident doctors than there are of the actual doctors.
Yeah.
It's so comparison. I don't know.
I want to get back to this question from Paul Revere. I got involved with the law about 2 years ago. Paul Revere, I know that's a pseudonym, obviously. Right after this COVID madness started happening, I was like, this isn't right, clearly. So I just started reading. We the people do not read the law as it's written. So we need to make sure that we do that. Read how it's written. Read the definitions of the terms. Something you're going to want to know and learn is, and I'm just going to put this little nugget out there, and this is homework for those of you watching. Get up onto any of your law websites where you can research terms and look for the term e justum generis. E justum generis. You're going to love that. That's a great one, and I actually used that in one of my legal briefs, and it worked out well. So, I thought what I like to do real quick too, Brett, is I want to show you the response that I wrote up for our magistrate's objection. My objection to the magistrate's order. So this is the case here. This is a convoluted case. We don't have time to go through all of this. And by the way, this case is probably on its way out for other reasons. I'll go into that later. But I got a report and recommendation from a magistrate judge, and I was very upset with it. And so I threw it back in her face, and I was really happy with it. So I wrote in here that we provide our written objections to several clear errors of law, including totally unlawful discrimination. And in the introduction, I go through really all the different things here, but I just wanted to touch on the memorandum of law and their erroneous application of the law and the rules. So this is where I talked about how this filing is timely, right? So we had 14 days. We did that in accordance with these rules. Talked about how the court has completely and utterly violated the undersigned's liberty, due process, and equal protection of rights. by allowing the magistrate to advocate on behalf of the defendants without adhering strictly to the law and the rules that govern this action, as well as those that govern the actions of the magistrate judges, and applying said law and rules accordingly. We did not consent to litigation being handled strictly by a magistrate judge. So we talked about that. Here's where I said we invoked an Article 3 constitutional court, not an administrative court. They have no jurisdiction to handle matters in an Article 3 court without leave of both parties. That's important to know. Both parties must consent to allow the magistrate judge to handle dispositive stuff on their own. They can still handle issues. And this is where here's the United States Code 28 U.S.C. 636 B1B that talks about how they can do that. But when you refer to the federal rule that we reviewed earlier, they must promptly conduct required proceedings and they must make a record of all evidentiary proceedings.
So they can't wait 6 months?
They cannot wait 6 months. No. But guess what? So I have a report and recommendation has been issued in 3 of my cases. Guess what is nowhere to be found in the record in any one of those 3 cases? Evidentiary proceedings. Nowhere. So my question is this, is how in the world can you dispose of a case without any evidentiary proceedings? Does that make sense to anybody?
Well, sure. I mean, they see it says pro se and they just say denied.
Yep, that's exactly right. Yep.
It's easy that way.
Yep. So what I did here is by getting this objection on the record, I preserved, and this is what Randy harps on all the time, right? I preserved the record for appeal if I wanted to go that route. We talked about how there's been no evidentiary hearing has taken place. I said justice delayed is justice denied. This court had these dispositive motions in hand for more than 4 months without a hearing or a ruling.
Way to bring it down there, James.
What's that?
Way to bring it down, the smack down. That was good.
Well, they also brought in matters that were outside of our 4 corners of our pleading, right? So if the
it
court
sets it up beautifully for appeal. You outlined exactly what is wrong.
Well, and this is my point too, is if they're going to do these things, if the magistrate judge is going to allow items that are outside of the 4 corners of my complaint in her consideration, then doesn't the rules and I would say the law required summary judgment procedure? Isn't that correct? It's Rule 12D. 12B, not 12B. Yeah, it's Rule 12D under the Federal Rules of Civil Procedure. Okay. So the only material that's on the record that could be submitted as evidence has been submitted by the plaintiffs, verified affidavits. We've got nothing from the other side. Nothing. So
wow.
So then I talk.
You're not supposed to know all that stuff, James.
Well, I
know. To be a good little,
I realize I'm just supposed to be the yes man, the yes sir, and just go along to get along. I get that, but that's not who I am.
Stop reading. My goodness.
Yeah. So then I go back, to the every single issue, and this is the way I like to outline the stuff in my replies. I want to go in the order that it's raised in the report. It makes it easier for me to read. It also makes it easier, in my opinion, for the judge that's looking at this to read it. So I talk about, there's a couple motions. We filed a motion to strike. We talk about how the court has inherent control over their dockets, which they do. Here's where we had a motion for entry of default. We requested the default judgment in the event the court would grant plaintiff's motion to strike. This was another interesting one, Brett, is that one of the defendant school districts, they actually defaulted. We filed for default judgment. They, the opposing counsel promptly opposed that. And they said, oh, I don't know how I missed this. We thought we got the same case. We missed it, blah, 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 blah. So then the judge, the district judge, not the magistrate judge, granted our motion for default and then promptly set it aside.
Set it aside?
Exactly.
Why?
I have no idea. No idea whatsoever.
No findings of fact and conclusions of law for that.
Nope.
Was it
Nope.
just sua sponte, or did the other side ask for them to set it aside?
Nope. There was nothing in the record where the other side asked for them to set it aside. So I'm considering appealing it on that part of it alone. The trouble I'm running into is I'm not finding very good appellate case law that would support that position on my end. So I'm struggling with, like, do I even want to bother with it at this point? So,
well,
anyway.
It sort of undermines. It's almost like not getting a ruling at all. If you get a ruling in your favor and then it's immediately set aside, that's almost like not ruling.
Mm-hmm.
Effectively, You've been denied the chance to have a ruling.
Yeah.
Because if he were to rule against you, deny you, then he would have to say why.
Mm-hmm.
He would have to put the facts and the law out there to say why. But what if he wants to rule against you and he doesn't have any facts and law? So then he can just say
make it up as he goes.
granted and then set aside.
Just make it up as he goes. Yeah. Yep. So anyway, that's what I did on that side of the fence there. But yeah, I don't know. I mean, it's just it boggles your mind sometimes. And this is what I want people to know and understand. You know, I know, Brett, you've got a lot of experience working with the Texas courts. You know, as does Randy. I, for one, this is my personal opinion and preference, I have seen nothing but corruption from the quote unquote judges in any of our local district courts here in Utah, and I want nothing to do with them. I don't have the time to try and finagle them into, you know, giving me the ruling that they're supposed to give me by law. And so this is where I feel like I'm just going to take this straight to the federal court, because here's what I know. I know that the justices that sit at the 10th Circuit Court of Appeals, every single one of them is a principled constitutionalist. I don't care if they have an R or a D behind their name or what their political affiliation is. The rulings that they're issuing are strictly constitutional rulings according to the way it's written and according to the rule of law. So
that's great.
So here's a great question from Richard. Did you file your 1983 in an Article 3 court? If so, it looks like you may have wanted to finish your question there. Brett, just so you're aware, or not Brett, Richard, just so you're aware, and I'll let Brett answer this. Every single federal court is, by law and under the Constitution, an Article 3 court. However, you have to invoke the jurisdiction of that by the sufficiency of your pleadings. So you need to make sure your pleading contains everything, all the required elements of a pleading. Your cause of action states all the required elements, and you support that with a verified affidavit or a jurat on your actual complaint itself. So that's how you invoke the Article 3 jurisdiction. And I could be wrong, but I don't think I am, because so far so good. So
yeah, I think you're right.
I mean, and really, you know, going back to the original question that Paul was asking, you know, how many years I've been working in this, you know, I just soak everything up. I listen, and this is one of the reasons why I was thrilled to have Brett here. I love listening to the Rule of Law Radio. There's always good things that are thrown in from, you know, people calling in. But I was also turned on to, and Brett, I don't know if you know him or have you met him, but I was turned on to Richard Cornforth about a year and a half ago.
No,
you ever hear of Richard Cornforth? You know who he is?
I've heard the name. I've never met him.
So he's an interesting fellow in that he was teaching and doing what you and what Randy do 15, 20 years ago. He's got a YouTube video that was filmed, I want to say 1992, 93, I want to say, where he's giving, and he was talking about the Patriot mythology stuff even back then. He talked about these people he was helping that went into court and they argued the gold fringe flag argument, and the court has no jurisdiction because of that, and blah, 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 blah. And he said that, you know, in the end, the court threw the book at him, which they did. And they, I guess this was in Arizona somewhere, and the court issued an $8 million judgment that was issued against there was like 5 or 6 defendants. and it was issued jointly and severally, right? So they're all supposed to equally share that. So he went back and reviewed the Arizona law, and the Arizona law outlawed that. So you got a judge that issued a ruling that's in contrary to Arizona law. So he actually filed paperwork properly in a federal court and had that judgment vacated. So anyway, he's a good dude. And that's where I learned, that's where I learned all about the jurisdiction of the court, how it's invoked by the sufficiency of the pleadings before it, which is like we just talked about, Brett, is, if you're brought into a traffic citation court, how they'll never prove up jurisdiction because they never initiate the proceeding the proper way. So,
all right.
This is a follow-up here. If so, is a magistrate appointed prior to a real judge? Yeah, Richard, we talked about this, is that if you file in federal court, they're going to want you to utilize a magistrate judge. You have every right to object to that and do. They're still going to be assigned. They're still going to issue reports on stuff you're filing into the cases. It's a pain in the rear end, but you want that district judge who was authorized by the Constitution to hear your matter. So
yeah, and the real judge is responsive to the electorate,
exactly,
whereas the magistrate judge is not.
Mm-hmm.
So that was the tipping. For me, I was thinking, well, maybe I should just let them use a magistrate judge, because then it will show the defendants that this is going to go through really fast, and they can maybe go ahead and come to the table, do a settlement, something that's we can maybe put pressure on them. But then I was like, no, I really want this to be an Article 3 real judge who has to be responsible to the people that elected him or her.
Yep. Well, and just so everyone's clear too, and I believe this is, let me just double check. I believe this is depending on the court or jurisdiction you're in, but here in the Utah Federal District Court, we only have one federal district court that covers the entire state. Magistrate judges are actually appointed by the district court judges. They're not elected. So I don't know how it is in the Eastern District court in Texas.
Well, it wouldn't be golfing buddies; it would be fishing buddies.
Mm-hmm. That's why it's terrible. It's like, right. So typically what happens in researching, these magistrate judges, they come and they go. Some of them are there for 6 months to a year. Some a little longer, hoping to get onto the court full time. But if they don't, then they have to say, okay, I'm done. I'm moving back onto my law practice. But the district judges, like you have your chief district judge, and then you have your other district judges that make up the court. They are the ones who, nominate and appoint magistrate judges to their courts. So where are they going to get these names? Obviously, it's going to be people that have litigated in their court. So yeah, they are golfing buddies. So anything else, Brett, that you want to add? I'd like to wrap it up here. I try to keep my shows to just about an hour. Erica knows I've been terrible at doing that. So anything else you want to add into give anybody, give some people some hope or anything else you want to throw out there? By obviously you got to jump off to get on the air with Randy here soon, but anything else?
Yeah, nothing else comes to mind about this.
Okay.
I would encourage people that if they have a need to deal with, they want justice, go get it. Don't just think, well, I have to learn for a lot of years first. I have to do some more. You're going to learn along the way.
Right.
So I would encourage people to just take the first step. And yes, you will see some filings come back from the other side. Go read what they said. They're going to put some case this or that. Like, I didn't know what Heck v. Humphrey was about until somebody tried to throw it in my face and say, this is why you can't have justice.
Yeah.
So go read what is Heck v. Humphrey about. Then find that it's totally not on point. Go embarrass the heck out of them.
Mm-hmm.
So yeah, just take step one. That would be my encouragement.
Yeah. Awesome. Erica, anything else you want to add? And before we end the show, I want to play a song that I heard the other day that I feel is, when you listen to the lyrics, it's very, I I feel like it's very appropriate for our time. Anything else you want to add, Erica?
No, I just want to echo that because like 2 years ago, I didn't even know what the Constitution was, who it was for. Okay, let's just be real about that. Like, there are people out there who live their whole lives, who have their government and econ classes in high school, who are never taught anything, and they keep this stuff from us on purpose, you guys. Don't ever feel condemned for 1 second that you don't know what we're talking about or what they're talking about. Just learn it like as you go. If your gut tells you that something is wrong, that it shouldn't be able to be this way, go with that, because there's probably a real like reason why it's not supposed to. And then you learn as you go. As I've gotten involved in my lawsuit, I was just like, they shouldn't have been able to do that. Well, I've been finding out why they're not able to do that. And until we call people out on how it's not supposed to be, well, we can't do it unless we know how it's supposed to be, really. Unless you know what your rights are, you don't really have any. So just make a commitment to like be learning what those things are, and don't be afraid and just go for it.
Yeah. You know, Richard brings up a really good point here. And I want to throw out these questions here. He just wants me to let everyone know you can complain from afar. And then he followed it up with against judges, attorneys, and magistrates. And this is the power that we...
Sniper on the hill.
Amen. This is the power that we as pro se litigants have. And this is what I love that Randy says. We're not dangling by our bar card, right? So I don't give two shakes what the judge thinks of me, what the judge thinks of my pleadings, what the other side attorney thinks of me or my pleadings. I don't care. The very first thing I do, and when I get a notice of appearance, is I bar grieve them. And what I love too is if it's a private attorney, so it's, Joe Blow from such and such law firm. Well, guess what? Those named partners are getting a bar grievance too. And we get a bar grievance every single time. Your next step, you want to talk about your nuclear weapon option. That is the judge's criminal complaint. Not the criminal complaint, excuse me, the judicial conduct complaint at the federal level, just like we were talking about. That's going to blow things wide open. So, all right, everybody, I just wanted to end with that. By the way, full disclosure, YouTube, I did not have permission to share that, but I found it on your freaking platform. So, boo. For those of you who are wondering, that band is Disturbed, and the name of the video is The Light. It's a great lyrics. I feel like it applies to our time. What really hit home to me was the chorus. When you feel all is forsaken, just remember sometimes darkness can show you the light. And I really feel like that's where we are right now. So everybody, thank you so much.
Light. Keep being the light. Even if you don't have to understand how dark the darkness is, just go toward the light.
That's right.
Be that light that people go toward.
That's right. Brett, thank you so much for jumping on. I really appreciate you spending the afternoon with us, and good luck on the radio show tonight.
Thanks.
Thank you. Thanks, Erica. Thanks, everybody. We'll take care.